Well, hello once again. You know, hopefully, who I am. My name is Lior Samfiru. That's right. I am the employment lawyer. And welcome to this chat with me. Welcome to this session that's designated to be a resource for you. I'm one of the founding partners of Samfiru Tumarkin LLP. We do operate in Ontario, in BC, and in Alberta. So if you have a question about your workplace rights, about employment law, about your job, now is the time to ask that question. Now is the time to get some answers and some clarity, and hopefully also some peace of mind. This is the name of the game. This is why I'm here. That's why I do these sessions every week. So right now, you have an opportunity to ask questions. Maybe you're in a situation like so many others recently that you've lost your job. I've been seeing that left, right, and center. You lost your job. You want to know if it's legal. You want to know if they can do that to you, what you're owed. Ask your question. Maybe you want to know if your employer can change your job, your hours, your pay, your duties. Ask the question. Maybe you want to know if your employer is allowed to discipline you. Ask the question. Whatever the issue, whatever the situation, you have time right now to not just watch me answer questions, to ask a question and have me answer your question. So I'm live here for you at your service for this purpose and this purpose only. Again, my name is Lior Samfiru. I'm the employment lawyer. And before we get started, let me give you some other contact information, because you may actually want me and my team to roll up our sleeves and get to work for you to help you actually resolve your workplace issues. Very easy to do that, and you should want us to do that. All you have to do is go to employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. When you go there, you'll find the contact information. You'll be able to contact me by phone, by email, my team as well, by phone and email. There's also a lot of resources and information that you can read about employment law and your workplace rights. So what a wonderful tool employmentlawyer.ca is. But that's for after. For the next 30 minutes or so, I'm here live for you at your service, answering questions about employment law and workplace rights. So don't be bashful. Don't miss out on this opportunity. Ask the question so that you feel better, so that you know what to do. Again, I'm Lior Samfiru with Samfiru Tumarkin LLP. I'm the employment lawyer, and I'm going to do what I do, which is answer questions. Our first question today comes from Ronaldo on Facebook, who says, I just started a new job, but the probation is 6 months. Is this legal? So it's not that it's legal or illegal, it's that it's meaningless. If your probation period is more than 3 months, it's meaningless. What I mean by that is after 3 months, your employer cannot let you go without severance. So whether they say you're on probation or they say you're not on probation, it doesn't change, it doesn't matter, it doesn't do anything. So it's completely meaningless for you to be on probation for more than 3 months. The only time an employer can let you go without compensation, just let you go, pay you nothing, is in the first 3 months of employment, and only if you sign an employment agreement that says they could do that. So remember, probation is not automatic. You're not on probation just because you started a new job. You're only on probation if you sign an employment agreement that says, hey, the first 3 months you're on probation, and during that time, we can let you go without any compensation and any severance. If that's what you signed, fine. But that period cannot really be more than 3 months. That's why it's meaningless. So it's not that it's illegal. It's not that it's a bad thing. It just doesn't do anything. So it's kind of a waste of time for the employer to bother with that. Hopefully that makes sense. Good question. You want to follow up, Ronaldo? Ask it. Happy to answer it. See how easy it is out there? Ronaldo had a question. He asked it. I answered it. Now he knows. He knows what his rights are. So ask yours as well. I'm going to continue answering questions. That's what I'm here to do. See how easy it is. Vera asks, due to a staffing shortage, I've been asked to work a lot of overtime. It's caused a lot of anxiety and stress, and my doctor is advising me to stop. Can I be forced to work it anyway? No. First of all, regardless of your medical condition, you can't be forced to work more than your regular hours. You can't be forced to work overtime. There's no mechanism for the employer to make you. That said, if you actually even have a medical condition, the doctor says, no, you shouldn't be doing that because for your health, it's too strict. Just get a doctor's note. Because at that point, if a doctor's note says you shouldn't be working overtime, if they try to make you do that anyway, it potentially can also become a human rights violation. It's a failure to accommodate. So they can't do that. So you can't be forced to work overtime, but that doctor's note, I can't emphasize enough how powerful it is. If you need accommodation, maybe you need to work reduced hours, different job, you need modified duties, the ability to work from home. If there's a medical reason for that, and your doctor puts that in writing, tells your employer about that, your employer has to find a way to accommodate. They have to find a way to make it work, to do what the doctor says. So that doctor's note is such a powerful tool that not too many people use, or not enough people use. So talk to your doctor, have that doctor's note. If your employer won't follow what your doctor says, call me. Okay, I'll get involved, and believe me, it gets resolved very, very quickly. Thank you for that great question, Vera. Again, you see how easy it is. She got answers. She knows what to do. She knows what her rights are. You could do the same thing. For those just joining us, my name is Lior Samfiru. I am the employment lawyer. Yeah, and I'm here live answering your questions. So ask your question, write it in, hit enter. I'll read it, answer it. All right, next question. Jude just did the same thing that I just said to do on Facebook. So Jude says, I want to know how a former company can see or be disciplining us after quitting. They're over 10 years, but seems from the beginning, a lot of internal things were going on in my personal life. Okay, I'm not sure exactly what you're asking, but no, a company can't do anything for you, to you, if you've been gone, if you've already quit. And if you've been there for 10 years, there's no legal action you can take against the company because there's a 2-year limitation period. All right, Seeing a Light on Facebook has the next question. I'm unionized, went on sick leave a year ago, was put on an unpaid leave. My arbitration is next month. My employer did not believe I was ill. I was 6 months without salary, many financial hardships this year. Should my employer be responsible for the losses? Well, that's what your arbitration is for, to determine whether or not your employer was right or not. And if they're not right, they're going to have to pay. Remember that if you're a unionized, this is important, not just for Seeing a Light, but for everyone. If you're unionized, the only one that's allowed to help you, to advise you, to represent you is the union. Okay, so you're within that unionized system, the arbitration and the grievance system. You can't hire me or another lawyer. It has to be the union. So I always kind of direct you back to the union. What we talk about on these sessions really only applies to non-union employees. Okay, non-union employees. That's because, again, if you're unionized employees, different rights, and the only one that can advise you on those rights is your union. So I think I've caught up right now so far on questions, but you have plenty of time still to ask questions. So do that. Ask your questions right now. Don't wait till the last minute. Every single week when I do this, every week without fail, when I'm just about to end, people start asking questions and then I can't get to them. Don't do that. You have time now. You don't have to be rushed. Ask your questions so that I can get to it. So thank you, JR, for the good comment. You have a question, ask it. While I'm waiting for the next questions, I wanted to go through a list. These are a list of kind of the worst times or the worst situations for an employer to terminate an employee. Okay, so but I'm waiting for your question. So here's kind of a couple points in terms of the worst times for an employer to terminate an employee. So one is, of course, when an employee is when an employee asks about taking a disability leave or comes back from a disability leave. So it's illegal. Your employer cannot let you go because you're thinking of taking a disability leave, are about to take a leave, or you're on a leave or coming back from one. If your termination has anything to do with your disability leave, it's illegal. It's a human rights violation, and there's going to be significant consequences for that employer. It doesn't matter if you're going to need to be off for a week, a month, a year, or longer. You can be off as long as you need to, and your employer can't do anything to you. And unfortunately, too many times I've seen employers terminate an employee. Well, you've been gone too long, or it's going to cost us too many problems. We don't want you back. Illegal, human rights violation. So that's definitely one of the worst times for an employer to terminate employment when there's anything to do with a disability leave. Hopefully that makes sense. I'm going to continue with that list in a little bit, but I want to answer questions. I'm going to continue answering a question that just came in now. Ask your question as well. I know you're watching, which is wonderful, and I appreciate it. I'd be even happier if you asked your questions. All right, Shivani asks, What are your rights if you're being forced to quit? A manager clearly doesn't like me and is trying to force me out. Don't do it. Okay? So they can't physically make you quit, right? So the only thing that happens if you quit is you could potentially be giving up on your severance. If they want you gone, let them let you go, and then you can get your full severance. That severance can be as much as 24 months pay, 2 years pay potentially, depending, of course, how long you've been there. So why would you give them that gift, that present? If you feel you're being harassed or bullied by your manager, tell someone at the workplace, the owner, the manager, the HR person. Let them know, because they then have a legal obligation, a very important legal obligation, to investigate that harassment and to fix the issue, to deal with it. So don't just kind of internalize it and try to deal with it yourself. Tell them they have to deal with it. It's not an option. If they don't, if they refuse, call me, and believe me, they'll deal with it. But don't quit in that situation. You're giving the company a gift, which could be worth tens of thousands of dollars. Don't do that. If you feel you don't have a choice, call me. Before you do anything, call me or email me. And of course, to get my contact information, we know what that is: employmentlawyer.ca. You see that address on the screen, employmentlawyer.ca. Phone numbers there, email address is there. Just easy. And by the way, you see the QR code there on the screen on the bottom. You scan that if you want. It'll take you to employmentlawyer.ca, and all the contact information is there. I love technology. All right, continuing to answer questions. I'm Lior Samfiru, employment lawyer. Now I'm answering question. Next question from JX2 on YouTube. If there is work available, but you are unable to do it due to medical reasons, would that qualify you for medical EI? If so, would that affect your regular EI eligibility later? So yes, you can if you can't do work, if you can't work for medical reasons, then yes, you do qualify for regular EI, absolutely. And no, it wouldn't impact your you qualify for medical EI. It wouldn't qualify for your or impact your qualification for regular EI. That said, I want you to also keep in mind this, that if you have medical restrictions, your employer may have to accommodate those. What I mean by that is you may not be able to do the job, your regular job, for medical reasons, but you may be able to do something else. Or maybe you could do your job in a modified way. Well, if that's the case, and that's what your doctor says, your employer has to make that happen. So it's not just because you can't do your regular job that means you have to go off on a leave or that you have to go off on EI. No, if you can do something else with help, with support, with accommodation, well, your employer has to find a way to make it happen. All right, so remember that. But yes, you can qualify for EI medical benefits if you don't otherwise have the ability to work at all. Keep in mind, your employer may also, depending on who you work for, they may also have insurance through a short-term or long-term disability plan that you can qualify for. So look into that as well. Okay, so thank you for that question, JX2. If you have any follow-up, I'm right here. Ask it. I can't imagine that this can be any simpler than what you're seeing right now. Questions are coming in, I answer them, and you walk away with that knowledge. So take advantage, do the same thing as all these folks have been doing over the last 15 minutes. Ask your question so that when we're done here, you don't wonder anymore. You don't regret not asking that question. Gonna continue answering questions. That's what I do. Melinda asks, I've been offered a new contract that changes my pay from salary to hourly. If I refuse, can they fire me? Well, the answer is you can always be let go with severance. So your employer can choose to let you go for any reason or no reason as long as they pay you severance. So can they say, well, your refusal to go hourly allows us to let you go? Yeah, because they don't need a reason. They can let you go because it's Wednesday and they feel like it, as long as they pay you severance. What they can't do, what they cannot do, is use that as an excuse to avoid paying you severance or to say that you somehow quit. No, because they don't have a right to implement that type of a change. So if you lose your job, that's what we would call a termination without cause, meaning you have to get paid your full severance. So usually when it comes to termination of employment, when it comes to losing your job, the question is, do I get severance or do I not get severance? The reason oftentimes doesn't factor in. So that's what this is about. Do you get severance? And absolutely you would get severance in that situation. It's a huge deal to be transferred from salary to hourly, or frankly, vice versa, from hourly to salary. So you don't have to accept it. And if you lose your job because of it, That's a without cause termination, and they have to pay you severance. Now, I mentioned severance, right? I talked to you a bit about severance. Well, here's how you actually can find out how much severance you are owed. So it's one thing to know that you're owed severance. It's another thing to understand how much severance, because believe me, it's a significant amount of money that you're going to be owed by way of severance. So how do you find out? Easy. Our regular viewers know this already. All you do is you go to pocketemploymentlawyer.ca. You see that address below me? Again, it's pocketemploymentlawyer.ca. Why do you go there? Well, because we have our severance calculator tool there. Our severance calculator tool does, as the name suggests, it calculates your severance, and it tells you how many months of severance you are owed. By the way, completely free, completely anonymous. You don't have to put in your name, the company's name. You don't have to put in a credit card number. You don't have to put in anything. Okay, you just answer some questions. You click on the answer, and it gives you the information. You would be surprised. Most people are shocked when they go there. They don't realize just how much severance they are legally owed. They think, oh, maybe I'm owed 2 weeks, 6 weeks, 8 weeks, and they find out they're owed 10 months or 18 months or 24 months. So check it out for yourself, pocketemploymentlawyer.ca. Use the severance calculator. Always the very first place you should go to if you lost your job, if you're worried about losing your job, or maybe you're just curious about what you're owed. All right, next question right now. Ask yours. You still have time. Ryan on YouTube. I've recently refused a demotion and followed up with reiterating that I don't accept the new offer, and the employer is stalling on their response. Is there a timeline, and am I at risk by working? So, okay, I understand what you're saying is that they've already imposed the demotion. So they've imposed a demotion. You told them no, to take that back. So the answer is yes. If you continue working, you're going to be at risk of being deemed to have accepted it. Generally speaking, once it's been more than a few weeks, 3-4 weeks or so, and you continue working, then you may be in a situation where you're deemed to have accepted it. So I would follow up with them again, but keep it on a very short leash. If you still don't get a response, you have to make a decision. The decision is, do you continue working and it is what it is? Or do you treat that demotion as a constructive dismissal? That means you leave and you require them to pay you your severance. Depending on the situation, that could be a very straightforward constructive dismissal. Of course, I do not want you, Ryan, to quit without speaking to me off air first. Do not quit without speaking to me first. I want to understand your job before, your job after, how it impacted your responsibility, your pay, etc. But this can absolutely be a constructive dismissal. You have to keep it on a very, very short leash. Okay. Any other follow-up you want, easy, contact me through employmentlawyer.ca. You see that address on the screen, employmentlawyer.ca. All right, JX2 has a follow-up. As a shift worker and knowing the work, I know I cannot, okay, I'm not sure exactly. Okay, I see what you're saying. So JX was saying that he's not able to work for medical reason. I said maybe he's able to get some accommodation, and he says that as a shift worker, I know I cannot due to the particular shift that was offered, but many other shifts I'm able to take. Well, there you go. So if you're able to take other shifts, then make sure you get a doctor's note saying you're able to take other shifts. If they say, too bad, we don't want to give those to you, even though otherwise they can, potentially that's illegal. Okay, and that could be easily a human rights violation. It could be considered a constructive dismissal, you name it. So get that doctor's note. It's not enough for you to say to them, oh, I can do those other shifts. That's not good enough. Your doctor needs to say what your limitations are and what work you can and cannot do. Your doctor doesn't have to say why. Your doctor shouldn't say what your medical condition actually is. That's personal and that's private. But your doctor should absolutely say, here's what the limitations are. Okay? So definitely keep that in mind. And if there's any problems, you know what to do, employmentlawyer.ca to connect with me. All right. Next question from Derek. After almost 20 years of my job, now my boss wants to remove paid sick days and says he doesn't have to offer this legally. Well, it's not that he doesn't have to offer it. That's true. It's that usually once your employer gives you something, it's difficult for them to take it back. I'll give you an example. Your employer only has to, by law, pay you minimum wage. Okay? Well, what happens if your employer pays you $50 an hour, 50, which is a lot more than minimum wage? Can they say, well, we don't have to, so we're just going to reduce it to minimum wage? No, because they can't change the terms of employment in a significant way. The question becomes whether or not by taking paid sick days, that's a significant enough change. And it comes down to how many paid sick days you had. So I'll give you an example. If you had 3, 4, or 5 and they got rid of it, not a nice thing to do, kind of a crappy thing to do, but probably not illegal. It doesn't rise to the level of constructive dismissal. But if you had 30 paid sick days and they got rid of it, that's a huge deal. And that could absolutely be a constructive dismissal. So it's a question of what has your employer done and how that's impacted you and what kind of a change is it. A couple of days, no. A significant amount of days, constructive dismissal. So hopefully that makes sense. Derek, any follow-up, you know what to do. Ask me now or just go to employmentlawyer.ca and connect with me that way. All right, next question today comes from N. Stinson on YouTube. You've said a new job may reduce the severance owed by previous employer. What is the mechanism for them to recover those funds and how would they know I got a new job? Okay, so let's take a step back because I think there's some confusion there. If you lose a job and we're dealing with the getting you severance, you have an obligation to try to find new employment. And if you find new employment and we haven't yet resolved the severance issue, then your new employer may have to pay less because you've been able to replace some of the income that you've lost. All right. So you have to tell them at that point, because if you don't, they'll ask the question and you'll have to be honest. If you don't tell them the truth and later they find out that you lied and because of that they paid you too much, they can take legal action against you. So it's all part of the severance negotiation. But the reality is, if I do my job, which I do, I can resolve that severance issue quickly before you find another job. And then it becomes it's a non-issue, okay? So that's why you don't want to wait if you lose your job. You want to deal with it quickly. You want us to resolve your severance issue quickly because you may find another job. You want that issue to be resolved before that happens. Hopefully that makes sense. So if you lose your job, don't contact me 6 months later. I'll still help you, of course. But the best time to contact me is right away when it happens so that I can get it resolved over the next 2-3 weeks or so that you get paid full severance and not have to worry about it. So hopefully that makes sense. And Stinson, if you have any follow-up questions, ask me. But if you're someone that is trying to deal with this issue of severance on your own, man, oh man, horrible idea. Horrible idea. Don't ever do that. So many things can go wrong. You'll be taken advantage of. I see this every day. Please don't do that. Okay? Hopefully that makes sense. I think I'm caught up on questions, but you still have some 7 or so minutes to ask questions. Take advantage of that. Ask questions. See, a lot of questions have come in, so I'm happy to answer them. As I was promising, in between your questions, I was going through a list of the worst times that an employer can choose to terminate employment. The next one on my list is when an employee raises harassment allegations. So if an employee raises harassment, if the employer fires them, God help that employer. That's going to be a significant problem. That's a huge issue. It's illegal. You cannot be fired for raising harassment allegations. You cannot. We call that a reprisal. That could also be potentially a human rights issue. It could be a wrongful dismissal. You name it, it's illegal. Instead, the employer has to investigate in good faith those allegations, even if it means bringing someone neutral from the outside to investigate, and ultimately deal with that harassment, fix it, make the issue go away. You should not ever be fired because you raised harassment allegation. All right, next question. Great questions today. Next one will come on Facebook from Jude. We are being blackballed from a former job place. This is so bad as it seems they went internal on us, going into our private life. Many people won't deal with us. So this is, okay, if they're defaming you, that's illegal. Not only that, if they're doing something to hurt you, that could be illegal as well. It could be various legal actions there that can happen. But if you're sitting here and not doing anything about it, it's going to continue happening. You can't resolve that issue by being on the computer and being upset about it. What you have to do is call me. Okay, let's deal with that, and let's get your former employer off your back. So contact me through employmentlawyer.ca. Again, employmentlawyer.ca, and let's fix that issue. Okay, let's get it done. So next question on YouTube from L Tran. Do you think there will be a lot of layoffs coming up because of the recession? Yes, absolutely, I do, and I think that's already started. I've been seeing over the past month and a half, maybe couple of months, a lot more terminations of employment than I have in a very long time. Even now, as we get closer to the holidays, we usually starting kind of in this point in November, we see less terminations, but I've been seeing a lot of them. And unfortunately, I expect that in the new year and in the first half and even in the second half of 2023, it's going to be a lot of terminations of employment. And, the recession, the economy are big factors there. So that's why you have to be aware of what you're owed, what your legal rights are in this situation. We do have good laws in Canada, whether you're in Ontario, you're in BC, you're in Alberta, we have good laws. Unfortunately, too many people don't know what those laws are. Well, if you're watching me right now, you do know what those laws are, at least some of them, especially when it comes to severance. You may lose your job because of no fault of your own, but you have to get paid severance. And that could be months and months paid to carry you until you find that new job, right? So that's why it's so important to understand those rights. But yeah, I've been seeing already a lot of termination. So N. Stinson says, I'm wondering how they actually recover funds from those previously paid severance. Well, I don't think you understood what I said, is they can't recover funds from those already paid. Okay, that's why I said if you've already resolved the severance issue, it's done. Okay, they can only get a discount if you're still dealing with the severance issue. So they cannot recover if they've already paid severance. JX2 on YouTube says, if after losing your job, you find new employment quickly, would an employer still owe you any severance, and does this change based on how long you worked for them? So that's exactly what I was telling N. Stinson, is they still would owe you severance, but it could be less because, let's take a step back. Why does an employer have to pay severance? The reason an employer has to pay severance is not to punish the employer for letting you go. The reason an employer has to pay severance is to help you while you don't have another job. So what flows from that is if you're able to find another job, then they have to pay you less severance because you don't have the same financial need. So yeah, finding a job can reduce the amount of severance owed. That's why, as I said, it's so important to get you that severance quickly before you find that other job so that it doesn't reduce your pay. And then you can essentially have severance and a new job and new income for the same period of time. That's why timing is important. Okay, very important. All right. Next question on YouTube from Philip Eno TV. I'm returning to work after 3 weeks unpaid suspension. They want me to sign a letter that has one term. Any further violation can result in termination with cause. I feel it's to avoid paying severance. Well, of course that's what it is, but the question becomes, what did you do? Did you do it? How bad is it? And what previous discipline do you have? So if you did something really, really bad, maybe it's appropriate that they say, if it happens again, we can let you go without severance. If this is all nonsense and you didn't do anything wrong, then it's not appropriate. So you didn't give me the most important information, is what did you do, and did you in fact do it? So my advice to you is don't sign anything until you contact us. So I understand the situation, what did you do, what you didn't do, how serious it is. So, if you were late once for 5 minutes, that's very different than, if you've been late every day for a month, as an example. So very important to call and not do anything without getting that advice. I think I'm caught up now, and that's the time that we have for today. So thank you guys for joining me. You see how easy it is to get answers. And just because we're going to end this session here doesn't mean you can't continue to get answers. How do you continue to get answers? Well, easiest way, I've said it already, go to employmentlawyer.ca, send an email, make a call, fill out a form with your questions. We'll answer the questions. We'll help you. We'll even talk to you. So it's employmentlawyer.ca. It's all there. Don't just think that there's no answers. There's answers, there's solutions, there's things that you can do. There are legal remedies that you have. All right. I'm Lior Samfiru. I'm the employment lawyer. I'm here every week at this time Don't wait till the next time I'm back. Ask questions today through employmentlawyer.ca. Wonderful questions today. I really appreciate your time and attention. I'll be back again soon. Take care.